and my ethnicity is Kamba.
So we'll start the interview. I want to give you 5 minutes to tell us about yourself and why you think you fit the bill of a judge of appeal. We want to know who you are and what you have done, what makes you suitable for this position. And as you finish it, maybe you tell us, what do you think are the attributes of a good judge of appeal?
Thank you, my lady, for the opportunity to appear before this panel. For this interview, I do not take it for granted. My name is Jacqueline Mbithe Mwinzi. I am an advocate of the High Court of Kenya of almost 25 years, come April this year, having been admitted to the bar on the 12th of April 2001. Since my admission to the bar, I have practiced law all the years, starting with the law firm of Ngoku and Associates, which was a short stint in the year 2001, between July and September 11th, when I crossed over to the office of the Attorney General as a state counsel. I joined there as a state counsel too, and have risen to my current position of Deputy Solicitor General and head of the Government Transactions Department. What this department does under the general mandate of the Office of the Attorney General under Article 156 of the Constitution of Kenya is to advise government on law, and specifically for this department, we advise government on matters touching on transactions which may take the form of procurement contracts under the Public Procurement and Asset Disposal Act. We also advise on agreements which are based on the Public-Private Partnerships Act. And we also advise on financing agreements. These are loan or credit agreements and also grant agreements under the Public Finance Management Act. In addition to that advisory role, I also represent the Attorney General in boards of state corporations. I've done that during my tenure in various boards. The first one was in the sector of sports. The name then was a Sports Stadium Management Board. I was the alternate to the Attorney General and did a tenure of close to 4 years. Thereafter, I went to the tourism sector, where I represented the Attorney General in the now defunct KTDC. I also represented in the National Irrigation Board, now National Irrigation Authority, and currently I'm representing the Attorney General in the Kenya Health Human Resource Advisory Council as the designated representative. I also attend meetings when delegated to, meetings which have to do with policy formulation. Because you have gone through my CV, you have seen the number of policies I've participated in, starting with the National Land Policy. Yes.
You?
Yes.
If you can tell us now your experience, that global experience,
yes,
how it makes you
yes,
suitable for the job.
Yes, for the Court of Appeal, I appreciate it's a collegial court, and how we work in the Government Transactions Department We work in teams. When a contract or a financing agreement is brought to us, we constitute ourselves into teams of 2 or 3 with the head of department, which is me, being the presiding person. A draft opinion is drafted by counsel under me. The supervisor looks at it. I also look at it to ensure that it is within the requirements of the law as applied to the facts presented. And if I can comment on the procurement contract specifically, where we have to look at what process was employed to arrive at a draft contract. We look at all the tender documents, all the correspondence.
Okay. That is also detailed.
Yes.
So who is an ideal Court of Appeal judge?
An ideal Court of Appeal judge is one who meets the requirements of professionalism, of competence, collegiality, a person of integrity. And coming in now, I think I fit that bill because I have been a person of professionalism, a person of integrity, a person who has demonstrated diligence and competence throughout my years of service thus far.
Thank you. I'll hand you over now to Justice Ishale to ask the next set of questions.
Thank you, Honorable Chief Justice. Ms. Mwinzi, some time back, a few years back, phraseologies like my dress, my choice, my body, my choice were very common. If that be the case, my body, my choice, why is attempted suicide still a crime under the provisions of Section 226 of the Penal Code?
Thank you, Commissioner, for that question. Yes, attempted suicide is an offense under the Penal Code because the Constitution has granted the right to life, which means then even a person is not entitled to take their own life. And if I can put it into context, supposing this person is a parent, by taking their life will be depriving the children of their rights, and that's why it should be dealt with in that manner.
Basically, what you're saying to us, and which is correct, that freedom also has limitations.
Correct.
All right. Now, in the area of criminal law, when an accused person has been sentenced, say by the trial court, and subsequently, and in this case we can say the trial court was the magistrate's court, and then he or she files an appeal, and the court is looking at the sentence that was imposed, and on the face of it, it is extremely lenient. It would want or it would like to enhance that sentence. What should this court do?
Thank you for that question once again. In matters sentencing, the law has provided for that, especially where there is a minimum and a maximum sentence, where the judicial officer in the magistrate's court would have the leeway to mete out a sentence which is within the minimum and the maximum. Then that discretion is allowed. I think if exercised properly, it should not be interfered with. But if there was a minimum sentence only, meaning that the judicial officer ought not to have gone below that threshold, then the appellate court would have reason to interfere.
You may not have understood my question, and I think I painted a scenario whereby a sentence that has been imposed by a trial court is on the face of it extremely lenient. And there is an appeal that has been filed at the High Court, and the High Court has looked at that sentence and has noticed that it is lenient. The High Court would want to have that sentence enhanced. What should the court then do?
Thank you for the clarification. I think there is provision in the law for enhancement of sentence, and therefore the appellate court will be properly applying itself in enhancing the sentence.
What should it do before it enhances the sentence?
It will look at the issues which were presented and the considerations which the judicial officer in the subordinate court considered in meting out the lenient sentence. And if there is justification to enhance, then the appellate court will be properly guided.
I shall not belabor this point. There is, of course, justification to enhance, and I'm asking what should the court do before it enhances. But there is justification because the sentence on the face of it is extremely lenient.
Perhaps we can come back to that.
All right. Thank you. Thank you, CJ.
Good afternoon, Ms. Mwinzi.
Good afternoon.
You have had occasion to interact with arbitration.
Yes, I have.
Now, as you know, arbitration is anchored on party autonomy and finality. From an appellate perspective, how do you conceptualize the proper boundary between judicial non-intervention and the court supervisory jurisdiction under the Arbitration Act?
Thank you for that question, Attorney General. I agree with the statement that arbitration is conducted and the understanding that parties have that autonomy to prefer their disputes to arbitration rather than taking it to the courts. But even when they do that and they are given a binding award, which has then to be taken to the courts for enforcement, the courts have to look at whether it is enforceable under the provisions of sections 37 and 39 of the Arbitration Act. And if there is a reason not to enforce, then the courts under that supervisory law will pronounce themselves accordingly. There is also the provision to set aside, which is also in section 35 of the Arbitration Act. And for the grounds given, if the arbitral award was awarded in circumstances which were irregular or against public policy and other grounds, then the courts have a reason to interfere and not make that award final.
Let's ventilate that a bit. Actually, public policy remains one of the most litigated grounds for setting aside arbitral awards. But how should the Court of Appeal guard against its overextension while still protecting fundamental legal values?
Public policy will have to be weighed against the merits of each case. For example, if an award is given which violates a public policy which affects other citizens, of course the courts will have to give a precedence to the rights of the citizen over those of the individuals in the arbitration.
So do you agree then that courts sometimes should not confine themselves to statutory grounds for intervention? And is there room for principled, constitutionally informed expansion of judicial oversight in exceptional cases?
I believe so. because my reading of the Constitution, and especially when courts are interpreting and implementing the Constitution, they are bound to do so in a manner which promotes the principles and values of the Constitution, and also to develop the law. So if the grounds which have been given in the Arbitration Act will require to be tinkered with, then the courts could rightfully suggest enhancement of those grounds, specifically to clarify how public policy grounds for not enforcing should be applied, so that there is objectivity, there is uniformity, and not subjectivity.
Thank you. Finally, for 25 years you've been in the office of the Attorney General, and for a long time you've been the head of Government Transaction Department.
Correct.
In interacting with arbitration, you've appeared before Parliament, you've represented the office of the Attorney General in international arbitration, and also in regional bodies, wherever there are disputes. In light of Kenya's socio-economic and infrastructural realities, are there aspects of arbitration practice that you believe Parliament should reconsider or recalibrate? And how should judicial decisions responsibly signal such need without overstepping constitutional boundaries?
Thank you. When it comes to arbitration, there is the law which governs arbitration, and even before we get to the law, there is Article 159 of the Constitution, which allows the various pathways which parties to any dispute could pursue resolution. And therefore, when a party selects to subject their dispute to arbitration, they will have to do that within those confines. Of course, respecting party autonomy. But when it comes to government, I know that there has been government guidelines, so as not to expose the government to a lot of expenditure when pursuing arbitration. So I believe that is an area where Parliament could pronounce themselves on, so that the parties, when subjecting their disputes to arbitration, they can do it within the confines which will be provided by Parliament.
Thank you, Chair. Council, I've read your CV, and I note that for 25 years you've mostly been at the Attorney General's office, particularly at the Department of I think government transactions.
Correct.
Do you have any experience within courts?
Yes, Commissioner. Part of my CV also demonstrated that for a period I was seconded to the Privatization Commission, which is a parastatal, where I served in the capacity of a corporation secretary, and I was head of legal. Apart from the company secretarial duties, I was also in charge of litigation at the Commission.
At the Privatization Commission?
Sorry?
At the Privatization Commission?
Yes, at the Privatization Commission.
Okay.
If you look at the Privatization Act, there are various dispute resolution avenues.
That's okay. That's
yes.
okay.
So I was involved in court work under that.
So the next question is,
yes,
why would you want to make such a I would call it a very extreme career shift from negotiating on behalf of government for treaties and transactions to come and sit in court?
First and foremost, I believe that I've matured in terms of legal knowledge, legal analysis, and understanding of statutes interpretation.
Okay.
And that is what courts do. And I believe that will be a value addition to the judiciary, and especially the Court of Appeal.
The Court of Appeal is a fairly superior court. Actually, 99% of the disputes of Kenyans end in that court. So one of the things that I think the Commission looks for is somebody who's ready to, occupy that position. So I want to ask a few questions in terms of the practicalities of the Court of Appeal. Can you tell us whether there are instances whereby a judge in the Court of Appeal sits as a single judge?
Yes, I am aware.
In which matters?
In matters of extension of time within which to lodge an appeal. Also in matters where a party is applying to withdraw an appeal.
Okay.
Yes.
And again, you've dealt with the international sort of transactions and treaties. Would you be kind as to tell us where the power would arise for extradition of somebody suspected to have committed a crime, say from Kenya to Rwanda?
Yes, there is a law on extradition, and when that law is being applied, there is also the need for reciprocity, whether there is an arrangement between Kenya and Rwanda for that extradition to take place.
Now, as far as I'm aware, there is no reciprocity in terms of the law between Rwanda and Kenya.
Yes.
And there's no arrangement of a treaty that exists currently between those two. Yes. So if Rwanda, if the government of Rwanda came to a Kenyan court through the available channels and wanted to extradite a Rwandese citizen here, how will that go?
I would look at section 2.5 of the Constitution, which makes the various principles of international law part of the laws of Kenya, and then apply those in considering the application.
But extradition is based on committee. So if there is no committee between us and Rwanda, how would that happen? Can a Kenyan court have jurisdiction?
I would say no.
Okay. Now, in respect to election petitions,
yes,
where does the last appeal lie for MCA matters, members of county assembly?
I would say the Court of Appeal.
No, they don't end in the Court of Appeal.
Members of county assembly?
Yes.
Let me reflect on that a little more.
Okay. Have you read that Supreme Court decision of Ogetonto versus Ogetonto on division of matrimonial property?
No, but I'm familiar.
You can't be familiar if you've not read it.
With the issues of matrimonial property division.
Yes.
Yes.
But the controlling authority should be the Supreme Court.
Sure.
So I'm asking whether you've read it.
No, I haven't read it.
Okay.
Yes.
All right. Thank you, CJ.
Thank you, Honorable CJ, and once again, welcome. Kili. Just a short discussion on the state of emergency. This must be an area of interest given the opposition and government, isn't it?
Yes.
Okay. Now, in what instances can a state of emergency be declared?
I know it is provided for under the Constitution, only in limited circumstances, such as a disaster, which is not a prolonged, because there are timelines which are prescribed in the Constitution, and that has been placed under the jurisdiction of the Supreme Court.
Okay. Now, can a declaration of a state of emergency act retrospectively?
Ideally, the general rule is that it should not, but there are exceptional circumstances and within timelines within which then what was done without the declaration will have to be regularized.
We are talking about a state of emergency in a country.
Yes.
It can act retrospectively. What's your view?
Could I refresh myself on that?
Oh, okay, thank you.
Okay.
Thank you. That's all. Thank you.
Thank you very much. I see from your application forms that you are actually a litigant in a matter in the Court of Appeal as we speak. So if you are successful and you find yourself with your colleagues having a matter in which you are interested in, how would you approach this?
The requirement is that I recuse myself after explaining the reasons to my colleagues on the bench, and then I do not proceed to hear that case at all.
Okay. You are, of course, familiar in your position with the advisory opinion jurisdiction of the Supreme Court.
Yes, I am.
Please tell us, who can seek an advisory opinion? Who are the parties that can approach the court for an advisory opinion? And what steps are required by any party before they bring an advisory opinion to the Supreme Court?
Thank you for that question. Parties to a dispute, which is in any court, can approach the Supreme Court for an advisory opinion, which advisory opinion will be necessary to inform how the dispute will be resolved, and also if there is a dispute between the two levels of government, then that is one instance where an advisory opinion can be sought.
Okay, but there are some steps to be taken before one approaches the Supreme Court for an advisory opinion. There's a required step. Do you know what that step is?
It escapes me, but I can refresh myself on that, Commissioner.
Okay. No, that's all for now. Thank you very much.
Thank you, Chair. Good afternoon once again.
Good
Jacqueline.
afternoon.
So we share a name and we write it as the same. I've gone through your sample writings. You submitted 5, and all of them are legal opinions. I also noted that they are not signed. All of them are not signed. I don't know why you did not think it was wise to sign them so that we can actually tell you are the one who prepared them. All the legal opinions are not signed.
That must have been an omission when I was submitting online, because after submitting online I printed and presented the hard copies. That must have been an oversight on my part.
Okay, but even the online ones you can still sign and upload.
Correct.
Thank you. I also note that there are internal memos. I consider them confidential. You ought to have redacted some information, or this is an internal memo, or even sought authority. I don't know whether you sought authority from the AG to use them, or your supervisor.
Yes, I did seek authority when I was getting the recommendation to apply.
You have that authority to use them as they are without redacting the information?
Not with me now.
Okay.
Yes.
Thank you. They touch on public law, procurement contracts, and infrastructure financing. And they are clear, and you are able to present sound analytical skills and apply the law in very complex scenario. So your reasoning is structured, coherent, and firmly grounded on statute. I noticed from your writing you appear to be a textualist. Am I correct to give you that title?
Textualists, meaning I go with what is stated in statute?
I expect you to know what a textualist is.
Yes. I would agree.
Yes, you would agree.
Yes.
So, and if appointed as a Court of Appeal judge, how would you approach a case that requires both, a case where strict statutory compliance points out to one outcome, but constitutional values, such as protection of public interest, appear to pull on different directions?
I would love to make a shift so that as I apply the law, I'm also promoting the principles and values of the Constitution. Yes.
What does the Constitution say about that particular way of interpreting the Constitution, and where can you find it?
That is the purposive way of interpreting the Constitution. I know it is provided for in the Constitution. If I get it, I'll give it to you.
Okay.
Yes.
Thank you. That is all, CJ.
Thank you, Chair. Good afternoon once more.
Good afternoon.
Yes, there is a fear that unchecked use of artificial intelligence poses an existential threat to human civilization. Now, what is your take on that, especially in the context of judicial function, and where do you see the role of a judge in the future in that context?
Thank you for that question. I know that use of AI is also being adopted by the judiciary. And then that calls for it to be adopted in a manner which is regulated. There has to be a law or guidelines on how it will be adopted, and mechanisms to deal with the risks which arise therefrom, so that the existence, as you put it, will not be under threat. Yes.
Do you think there is a possibility that in future, the judiciary of the future, AI may take the place of the judge, so that the judge is rendered jobless or with no role to play?
I do not think so, because AI, in as much as we would want to say that these are not human beings, they do not have consciousness, they do not have minds, but there are systems behind that, and they are created by human beings, and there could be limitations. what AI can do cannot automatically replace what a physical court can do. So I do not see that possibility at all.
Okay,
Yes.
thank you. I wish you well.
Thank you.
Thank you and welcome again.
Thank you.
What is the role of the judge of appeal in management and oversight of judicial resources?
Thank you for that question. I know that at the appellate court, these are people who are in a position of leadership, and under the Constitution, the people who are in leadership and especially in the public service are expected to ensure that there is a prudent use of public resources. So a judge in the Court of Appeal will be called upon to ensure that the resources, if it is motor vehicles, if it is staff, that those resources are used prudently, because they are held in trust for the people of this republic.
And could you also explain the legal framework on financial accountability?
I would start with the Constitution. There is Article 229 on the role of the Auditor General. Then there is the Audit Act, which governs how the Auditor General conducts those audits. And then the Public Finance Management Act also talks to the audits, how they will be conducted, and where the audit reports end up. They're also supposed to end up in Parliament for debate and oversight.
How would you address a situation where a party alleges bias due to prior academic publications situations?
Sorry?
How would you address a situation where a party alleges bias due to your prior academic publications?
Biasness is something which should not arise for a person holding an office in the judiciary. And if a party alleges that there is biasness, then the party alleging will need to prove that. And if it is not proved, then the judicial officer, the judge, will have to continue handling the case. If there's an appearance, of course, then because of the quality of the requirement that a judge should be impartial, which means there shouldn't be any appearance, then that then calls for either recusal or to transfer of that matter, so that there is no appearance of biasness.
Thank you, Chair.
Thank you, Honorable CJ. Council, I have a few questions for you. What do you understand by the term transformative leadership?
Thank you for that question. Transformative leadership is one where the leader is looking at how to improve the organization through ensuring that there are mechanisms in place on how to achieve the objectives, how to be innovative, how to ensure that the employees are carried along and they can perform optimally.
Okay. Given your answer, are you a transformative leader? And if yes, could you describe a situation in your professional work where you can take credit for transformation that took place?
Yes, I believe I am a transformative leader. I can give a couple of instances.
Just give us one.
Yes, while at the Privatization Commission, I initiated a process which saw a change from the terms and conditions of the staff of the commission. When I joined, all the staff were on contract. But when I was leaving, I had proposed and recommended to the board that there is need to change the HR instruments so as to place the lower cadres on permanent and pensionable, and only the three upper cadres to be on contract, and that went through, and I'm very proud for causing that transformation to happen.
Okay.
Yes.
What are the responsibilities of an employer in protecting employees from sexual harassment in the workplace?
First and foremost, the employer will need to put in place a policy which is in tune with the Constitution and other laws. There is also need to have a whistleblower policy where if instances arise, one can safely report, and also a disciplinary mechanism that arises so that anyone who offends then can be dealt with according to the laid down procedures.
Okay, finally from me, could you tell us of a time where you're faced with an ethical dilemma at work?
Yes, one example is a time I'd traveled for an assignment out of the country, and I ended up spending fewer days. And of course I had to surrender the per diem and the allowances which I had been given. And when I was seen to be doing that, was being asked, why can't you just submit the documents indicating that you were out there for the entire period? And because that was not the right thing to do, I had to surrender and refund the monies, and I felt that that was the right thing to do. Okay. as a public officer.
All right. Thank you, and I wish you well.
Thank you.
Thank you, CJ.
Yes. Now, what does community service mean to you? Community service.
Community service would mean outside my employment, I have to give back to the society, either by pro bono services or supporting development projects at the community level.
Yes, what specific community needs have you worked to address?
Thank you for that question. I have given free legal services to various groups where I stay. If they are chamas, they want to come up with constitutive documents, I help them with that. Where they need the services of an advocate, because I am not practicing, I refer them. Where they need to take minutes, I also assist with that free of charge. Then back home, I've been a member of a board of management in 2 secondary schools, and I consider that as a community service.
Why do you believe community service is important in public institutions?
Public institutions are using resources which are basically from the taxpayers' money. So community service, and especially in the form of corporate social responsibility initiatives, will be like giving back to that community, so that at least they can feel that they are being supported. Yes.
Thank you very much, Honorable Commissioners and Ms. Mwinzi. I think this brings us to the end of this interview. Thank you very much for coming, and we would like to give you this opportunity now for you to address us so that it is not a one-way traffic. You have the floor to tell us whatever you want to tell us.
Thank you, Honorable CJ, for the opportunity. First and foremost is to thank the JSC for granting me this opportunity to appear for the interview. I note that I was also shortlisted in the previously cancelled one, and now that this one has materialized, I am very grateful for the opportunity. And given the opportunity, I would help with the reduction of a backlog in the Court of Appeal, and also in promotion of access to justice, especially in the area of criminal law. I've been